morning all of you, and welcome to our wonderful world of copyright for management. This interesting website, this webinar is on behalf of Kingston Education. The topic copyright for management is extremely relevant in modern business, for management students, entrepreneurs, and also for all business people. This topic, copyright for management, this is becoming one of the most important and significant part of business, and it is the matter of extensive litigation also. Now let us begin with what is copyright. Copyright is basically a virtual wealth. It's a wealth, it's a business asset like land, building, plant, machinery. But it is considered to be an intangible and invisible asset. It's a business asset, but it's an intangible asset, invisible asset. So let us begin with what is copyright. Copyright is not a right to copy. Some people misunderstood the term copyright as the right to copy. Recently I asked a CD shop owner, what is the meaning of copyright? He said copyright is the right to copy. But copyright is not the right to copy, but copyright is the right to prevent copy. Copyright is a right of an owner of a work to prevent copy. That is why it is called a negative right. It is not a positive right, just like a driving license or a passport. A driving license gives you a positive right. Because you can drive a vehicle, it does not mean that other people cannot drive. But if you have a copyright, you can use it, but other people cannot use it without your permission. That is why it is called a negative right. Copyright is a negative right. It is not a right to copy, but it is a right to prevent other people from copying. It is a right of the owner to prevent other people from copying. And by this time, the owner of the work can use it, commercialize it, license it, and whatever way he wants to use it in business. It is the right of the creator. Copyright is the right of the creator or the author or the owner of a work to use and commercialize the work for a fixed period of time. There is a fixed period of time which is given under the legislation. Certain copyrights are given, certain copyrights are registered and certain copyrights are not registered. Copyright registration is not compulsory, just like other registrations. Once your work is completed, your work means your novel, your computer software, movie, whatever it is, whatever a picture, a photo, whatever it is your work. Once the work is created and you put it in a tangible form, the copyright subsists. No formal form of registration is compulsory for a copyright to clear a copy, to get a copyright. But it is for a fixed period of time. For example, the life of the author plus 60 years. For normal work, it is the life of the author plus 60 years. Till that time, it is your property. The government gives you complete right. The legislation gives you complete right. But after that period, this particular work goes to the public. The public can use it. The public can use this work. Ramayana and Mahabharata are in public domain because Ramayana's copyright period is over. Mahabharata's copyright period is over. So these are in public domain. So if you wish to take the story or certain paragraphs from Ramayana or Mahabharata, no permission from the owner is needed. You can straight away do it and take it. The pictures of Mona Lisa, all these are in public domain because the copyright period has already expired. Copyright is an exclusive right granted by the law for a specified period to the creator of a work. It is against any form of copying by an unauthorized person. What is the object The object is to protect the author or the creator of a work. The legislation gives certain supports by way of providing a monopoly to this particular person for creating this work. If I have created a work, the government or the legislation gives me a right to use it for a fixed period of time. During this fixed period of time, if other people are misusing it, I can take action against that people. So this is the right granted by the government or the legislation to the work owner. The owner of a work. What are the terms or what are the items covered under copyright? There are different items covered under copyright. Number one, literary work, like books, novel, poetry, screenplay. All these are literary work. And in India, computer software is also treated as a literary work. Dramatic work, musical work, artistic work, sound recording, film, and characters. These are the things covered under copyright. So for each items, the owner is having certain rights. We will generally call it as ownership right. This ownership right is collectively referred to as copyright. As far as the character is concerned, the characters like Mickey Mouse, the value of Mickey Mouse is crores of rupees. So, even the character is also the subject matter of copyright, and the owner of that particular character is the copyright owner. The other people cannot misuse this particular character without the permission of the copyright owner. These are the things covered under copyright. Literary work. As far as an office is as far as a company is concerned, there are a lot of literary work. For example, the data of the company, the managerial information, confidential information, trade secrets, and dramatic works, musical works, artistic work, film. All these are the subject matter of copyright. So copyright is basically a legal vehicle to protect the work. So, in company perspective, it can be viewed in two perspectives. Number one, as a manager, you have to take special caution or special care for protecting your company's work, for protecting the copyright on your business, the works owned by your business. That is number one. Number two, during the course of your business, you should not interfere or you should not infringe the copyright of any other people. The copyright infringement happen in several aspects or in several instances, like a website or during product packaging or for any other mode. So you should be very careful. As a manager, you should be very careful about copyright infringement. You should not infringe the copyright of other people. Copyright is globally governed by two international conventions. One convention is Berne Convention and the other convention is Universal Convention. Therefore, a copyright which is created in India will be protected globally. So for example, you have created a work in India and this work will be protected globally. Even though you go for a registration, a copyright registration under the government of India, you need not go for another copyright registration in US or Dubai, because this particular copyright registration in India covers globally because of these two international treaties. What are the basic features? Copyright is governed by Copyright Act 1957. It's a creation of statute. There are multiple rights. And copyright subsists only in original work. In order to claim copyright, your work must be original. It should not be copied from anywhere. And no formalities like a registration, etc. are needed to create or to claim a copyright. And there is no copyright on events. So copyright is a form of intellectual property. Intellectual property is the property created by using human intelligence. Basically, there are two types of intellectual property, copyright and industrial property. Under industrial property, patent, trademark, etc. are covered. Under copyright, only copyright is the single subject matter covered under copyright. Copyright in India is governed by Ministry of Industries and Commerce. It is, the office is coming under Ministry of Industries and Commerce, Ministry of Higher Education. The other trademark, patent, etc. are covered under Ministry of Industries and Commerce. Copyright is falling under Ministry of Higher Education or Ministry of Human Resources, Department of Higher Education. Copyright is basically an intangible asset. It can be registered or cannot be registered. Copyright can be used either as own copyright or licensed. Then how to protect your copyright? As a manager, the most important problem faced by a manager in your organization is to protect the copyright owned by your company. There are different ways of protection of copyright. The first way of protection is getting your copyright registered. Registration under Government of India is the best way to protect your copyright. But I have already said registration of copyright is not compulsory. Registration of a copyright is not compulsory. Then why people are going for registration? The reason is, even though the registration is not compulsory, when you go for a court case, when you go for a litigation, the court will specifically ask for the certificate. The court will specifically ask whether your work is registered or not. If your work is not registered, your work will not be eligible for legal protection. Therefore, it is always advisable to have your work registered under Government of India. Under Government of India, there is an office in New Delhi for registration of copyright. There is a single office which is in charge of all the states of India. So, all the companies or the individuals wish to file copyright registration should file application in Delhi office. The second method is putting copyright notice. Once your work is completed, for example, your software or a novel or a literary work is completed, you can put a copyright notice, putting C on a circle and putting year and the name of the author. This is called copyright notice. So copyright notice is an indication to the general public that this particular copyright is owned by this particular person. So he has created on this particular year. So nobody has any right over this particular copyright. So this is the this is the most important form of copyright protection, which is generally adopted by people and companies for protection of their copyright. And there is another way of protection, like registering with association. For example, a script. Normally the film scripts are registered with Writers Association. And these kind of registrations will give a limited protection, not a complete protection. Only the government registration will give complete protection. This kind of registration will give a limited protection to the work. And in countries like the US, there is a system of sending the copyrighted work on an envelope and sending it to registered post to his own address. For example, a work is completed by an author. So the author put that work on an envelope and he writes his own address and send it to that is posted by registered post. Once he receives the letter, he will keep the letter with him. If there is a dispute with regarding the title or the date of such work, this particular letter is a conclusive proof that this work has existed at the date of the registered letter. So this is normally known as poor man's copyright. So these are the ways in which individual or company protects copyright. So what is the term of copyright? For literary work, dramatic work, music and other artistic work, the copyright period is the life of the author plus 60 years. If you have created a work, it will remain as your property for a period of 60 years after your death. Not from the date of the work, but after your death, after the author's death. So the term of copyright protection is the lifetime of the author plus 60 years. For other work like photograph, movies, etc., it is the 60 years from the date of the work. If it is a movie, it is the date of the release. If it is a photograph, it is the date in which the photograph is taken. So in organizations, copyright is on artistic work also. For example, a logo, the corporate logo. The corporate logo, if you are using a corporate logo for your business, this corporate logo is the subject matter of a copyright also. So you should get it protected from unlawful misappropriation. For example, this particular logo should not be used by any other person for any other purpose. So you should protect it as copyright also. This is the most important thing which HR manager has to be very careful about protecting their copyright in the organization. What the HR manager has to do in an organization for protecting the copyright is, number one, to get a non-disclosure agreement or get a confidentiality agreement with the employee. When a new employee is joining in an organization, the HR manager has to get a non-disclosure agreement or a confidentiality agreement to be signed by this employee. What is the purpose of this non-disclosure agreement? The non-disclosure agreement is used for protecting the information, and this certain information in the organizations are considered to be highly confidential and considered to be trade secret. So this particular employee should not share the information with other people. So if there is a copyright issue, this particular agreement will be a prima facie evidence for taking an action. And in company's policy, HR document, the company should incorporate a copyright clause, a specific copyright clause which educate the workers, educate the employees regarding the importance of copyright. Importance of copyright in the sense that the company is the owner of several copyrights, and the employee should not work in such a way that to make any infringement of the copyrights. And most of the copyright issues are creating in the corporate world by way of social media issues. So you should have a separate social media policy for posting information regarding the company. And another important issue is the data theft. Data theft is the most important issue which is faced by companies. One employee is leaving the organization, he is taking with him a lot of data, and he is taking with him a lot of confidential information. The company is filing a case against him. So these kind of issues are very relevant in modern corporate. So for that purpose, the company should be very careful about the people who are using laptops or the people who are working at home regarding the seriousness of the work or regarding the seriousness of the data. The company should have strong policies on the company HR policy regarding the confidentiality and the seriousness of the copyright issue should be educated to the workers. And certain information must be specifically treated as trade secret also. Then how the copyright mechanism works. An author creates a work. This particular author put the mark C, copyright notice, or this particular author gives certain registration and other details, and then he can completely commercialize or use it for business. This is the most important principle. There is no copyright in ideas. If the idea is put it in tangible form or in a concrete form, that is a copyright. If you have something in your mind, if you have an idea in your mind, if you have a concept in your mind, that concept cannot be copyrighted. That idea cannot be the subject matter of copyright. That idea, when it is put it in a tangible form, that has a copyright. This has been clarified by an important case, R.J. Anand versus Dealers Phillips, which is a very important case in Indian judiciary, with the judgment has been pronounced by Supreme Court of India. And now there are a lot of issues with regard to the new technologies. The technology is changing very fast, and there are a lot of issues with regard to the new technologies. So in an organization, when you are in a particular job, you have to check when you take the work of some other person. In an organization, you are sharing the work with other people. In the internet also, you are taking contents from various websites. So these various contents sometimes may be copyrighted. So you should be very careful in an organizational perspective and in personal perspective. You should be very careful while taking contents from website, while taking contents from internet, or sharing contents to others. So first of all, you have to check who owns this particular copyright. Then get a permission from that particular person. If you are using another person's work without his permission, it is basically a copyright infringement and he can file a case. So, if you are commercially using a particular work, if you are commercially using the contents of a particular work, you should get permission from the owner. And also, if it is a movie or something, you have to give proper credit to that particular person. There are certain cases, or there are certain issues in which, or there are certain circumstances in which you can illegally use copyrighted material. That is, technically in copyright language, it is called fair use. It is known as fair use. Fair use is a situation in which you can use copyright material of other people legally, but not for all purpose, but only for educational and research purpose. Not for all time, or not for not the complete contents, but only the limited contents. The limited use for education and research purpose. It is a restricted use. A restricted use of copyright material for educational or the research purpose. There is a recent case in Delhi High Court. The case has been filed by Oxford University Press. The case has been filed against one small photocopy shop in Delhi University campus. So the allegation against the case was for copyright infringement. The Oxford University Press is claiming that these photocopying shops are largely photocopying high quality books, highly priced books. So each photocopy is a lost sale. So for example, a book costing rupees 2000 or 4000 is simply taking photocopy for 100 rupees or 200 rupees. So it's a lost sales and creating a huge loss to the publishers. So this is a copyright infringement, and they have filed a case in the Delhi High Court. So Delhi High Court has immediately issued an injunction, and the case is still pending in Delhi High Court. So beware, you should not take copies of books. You should not take photocopies of books. Taking photocopies of books is a copyright infringement. But there are some exceptions. If you are using it for educational or research purpose, it can be included in fair use. But you should not take the whole book. You can take only limited contents. So in the internet also, there are a lot of copyright issues, even in YouTube. So the recent amendment in Copyright Act has added a policy, a principle of safe harbor to the internet service provider, like YouTube, Facebook, etc. If somebody has put a content in the YouTube or Facebook, and that particular content is a copyright violation, anybody can file a complaint with YouTube or Facebook. So this service provider can immediately issue a notice to the content provider to remove the content. But the copyright owner cannot file a case against this service provider. This principle is called principle of safe harbor, which is incorporated in the new copyright amendment in 2013. So this is one of the interesting cases with regard to the happy birthday issues of copyright. This is one of the newspaper cutting of Hindu newspaper 2 or 3 months back. So Happy Birthday to You song is the song which has a place in Guinness book, which is a song which is sung by a large number of people. This particular song is the copyright property of a big music company. The music company's name is Warner Chappell Company, and this particular company is demanding royalty from people who are using this particular song in movies, in serial, TV serials, etc. So, if in a movie or in a TV serial, if the characters are using this particular song for cake cutting or birthday celebration, they have to give a royalty to this particular company. But once you read this news, it is very clear that this particular company has been illegally collecting royalty. Recently, one case has been filed in US court saying that this particular company has been illegally collecting royalty for several number of years. Actually, their copyright period has expired long back. So, the Federal Court of US has recently held that this particular company has no right to collect royalty from those who are using this particular song in movies or serials. So this is one of the good judgment in the copyright world. There are few in Indian perspective, according to Section 55. Copyright infringement is the using of other person's copyright without permission. It covers a lot of things, even the pirated CD also it is coming under copyright infringement. Software piracy, pirated CD. So all these are coming under copyright infringement. For copyright infringement, the copyright owners are seeking any of this kind of remedies. One is Ant-and-Pillar order. Ant-and-Pillar order is an order of the court in which the court will appoint a court commissioner, and along with the commissioner, the order of the copyright can enter into the premises of the offender and seize. He can completely seize and raid the entire things to check whether there is any copyright infringement or not. Microsoft is always doing it for software piracy. Getting an order and getting a complete computer raid in an office. Then there is a John Doe order, which is normally known as Ashok Kumar order in India. In other countries it is known as John Doe order, but in India it is known as Ashok Kumar order because it is first introduced for a case, Ashok Kumar case. That is why this particular order is called John Doe order. John Doe order is an order of a court in which a case has been filed against unknown defendants. A case is filed against unknown persons. Recently, a few days back, there is a case for Uttar Punjab. A case has been filed by the producer of the movie Uttar Punjab against a lot of websites allowing illegal copying of the movie. The Bombay High Court has issued a John Doe order restricting or prohibiting the service providers, restricting these website providers from unlawfully and illegally copying this particular movie. And in several Indian movies, this particular order has been passed. On the releasing date, the producer has an apprehension that his movie there is a chance of this movie widely being copied by different websites. In that case, he can get a John Doe order from the court and he can take action against the service providers. So now the employment opportunities for MBA students and other students. What are the employment opportunities in copyright and trademark? So this is clubbed with other intellectual property like a patent and trademark. After completing your MBA, if you are a graduate, you can take down the test of, there's a test which is conducted by Government of India. The entrance test is called the Government of India's Trademark Agent Examination. You can take down this Trademark Agent Examination and you can become a trademark agent. And it is a government licensed job. And by getting a trademark agent, you can also advise on copyright also. That is number one. Number two, if you are a science graduate you can write the patent examination test which is conducted by Government of India. That is allowed only for science graduate. It is conducted by Government of India once in every year. So, once you clear the patent agent examination, you can advise on patent filings and copyright filings also. If you are a BTech or if you are a PhD, you can become a patent agent and join in law firms and corporates. Now, what are the rights of a copyright? Well, once your organization has a copyright, what are the rights granted under copyright? Number one, there are basically two rights, broadly two rights. Number one, economic rights, and number two, moral rights. Economic rights are the rights to reproduce the work, making copies, changing the work, then publish, distribute and translate the work, perform, communicate the work, make adaptation, sale, license, etc. So these are the things covered under economic right. Copyright covers two rights, economic rights and moral rights. Moral right is basically the right of an author to retain his name as the creator. When I purchase a Chetan Bhagat's novel, that novel is known as Chetan Bhagat's novel. When I purchase it, it cannot be my novel. It is Chetan Bhagat's novel. When I purchase a pen, once the purchase is over or once the sales process is over, it is my pen. But once I purchase a novel, it is not the novel of the purchaser, but it is the novel of the person who has wrote it. It is the novel of the author. This particular right is called moral right. It is different from economic rights. So corporate organizations, business organizations always give importance to economic rights. But while giving importance to economic right, they should not forget about the moral right of the author. It is a right of attribution, a right against the false attribution of authorship, a right of integrity of authorship, duration, etc. For example, once an author transfers all the right to a publisher, this publisher can sell it, the publisher can utilize this particular right, but he cannot change the contents. The publisher cannot change the contents of this particular book. This is a part of the moral right. It is a part of the moral right given by the legislation. Mere selling of an article does not mean that transferring copyright. When I purchase a book, I am purchasing a physical form of the book. I am not purchasing the copyright. When I purchase Chetan Bhagat's novel, I am just purchasing the physical form of Chetan Bhagat's novel. I am not purchasing the copyright of this particular novel. So mere selling of an article or mere buying of an article does not attach the transfer of copyright. So this is very important from business perspective. Now let us see what is the difference between copyright and copyleft. We have said copyright is the right of the owner to take copies, commercialize it, distribute it, etc. Copyleft is the author or the owner is leaving the copyright to the public. After completing the work, the author says, I do not retain any copyright, I am leaving it to the public. You can make it, you can make use of it, you can copy it, whatever it is. In computer perspective, there is a limited permission is given. But generally, it is the situation in which the author leaves the complete rights to the public. Normally, copyright has a period. After this particular period, the right will go to the public. Copyright protection for a work begins when the work is fixed in some sort of tangible form. This included writing, typing, etc. Even an email is also got a copyright. The email copyright, once an email is sent, copyright subsists. The copyright is created. That email, according to Information Technology Act, that email will also be accepted as a concrete evidence by a court. Therefore, email is also a subject matter of copyright. So all your business contents, even email, your confidential information, your data, your clients list, your marketing information, All these are the subject matter of copyright, and as a business manager, you have to protect this particular property, this copyright, without any misappropriation from the public. So this is the subject matter of copyright. Recently, there are certain amendments in the Copyright Act in 2013. Certain amendments I have mentioned earlier. Most important amendment is with regard to the work for hire. This is one which HR manager must be very careful in an organization. Once an HR manager appoint a person, there are different type of appointment like permanent employees, contract employees, and last one is appointment for a particular work. Appointment under a work for hire agreement. That means a person is engaged to complete a work. Once the work is completed, he will leave the organization. So there is no employer-employee relationship. So once the work is completed, the copyright of the work is transferred to the company. That is very important. Once a work for hire agreement, once a person is appointed under work for hire agreement, once the work is completed, that work, the copyright on the work is transferred to the company. So this particular point must be very carefully incorporated in the work for hire agreement. But the new legislation, the new amendment in the copyright says that this particular point, this transfer of copyright or assignment of copyright to the company is not permitted in all circumstances. These kinds of things are not permitted. Even though the rights are assigned, this particular employee is having certain rights. This particular employee who is doing the work for hire is having certain rights. He will retain certain rights. For example, in film, once a film is once a film is making huge revenue, this person who has created the work is also entitled to a portion of the revenue. In several movies, the movies are remade in different languages, but the original scriptwriter is not rewarded by all these revenues. The problem is with regard to the execution of agreement. In most of the cases, in film world, most of the cases, the movies are happening just because of friendship, not because of contracts and purpose. There are a few contracts signing, and mostly it is happening on friendship. So once a person who has signed a contract for the script or the story of a particular movie, normally this particular person is not incorporated any clause to the effect that when this movie is made into another film or it is remade into another film, his permission is needed or he is entitled to get a portion of the revenue. If these kind of wordings are not included if it is not included in the agreement, this person is not entitled to get any revenue. But the new legislation says that this particular person is entitled to the revenue even though it is not included in the agreement. So this is very important. So piracy is the most important problem which is faced by Indian companies, especially in film world, film industry, music industry, and also in book industry. It is very common in film field, movie field. The movies are being copied, the new movies are being copied, and it's being sold. And some people are downloading it from different websites. And in software also, people are using pirated software. Instead of using the licensed version, people are using the pirated software. But one of the most important point which we have to take care is, once this particular issue, that means in case of copyright, in case of software, your company should not use any pirated software. All the software must be licensed software. So this piracy is a great curse to the modern corporate world. This is basically a theft. It's a data theft. But it is different from original theft. In original theft, once you steal a property, that property will not be there. But in copyright theft, once you steal a property, that property will also be there. But the person is just copying. A and B. A is also having a copy, B is also copying. A is having the original and B is also having a copy. So, copyright is the most important, precious business asset. Therefore, the business manager should take special care for the protection of copyright. For the protection of copyright in the sense, either you have to register it or you have to protect in some other way. And you should also careful about the fact that you should not infringe the copyright of other people. While using internet, while sharing the contents, or while taking the contents from internet, you should be very careful and you should ensure that you are not breaking or you are not infringing the contents of the copyright version of the contents. So this is the end of this section, and you can visit our website at www.nibmglobal.com. And also you can also join in our YouTube also. You can watch the entire session of this seminar from the YouTube session. So thank you so much.